All right, we are in our final chapter. Way to go! And this is kind of the catch-all chapter for all the remaining issues regarding corporations, or most of them. So go ahead and read your chapter objectives on your own. And we've talked about it before, but we're going to keep mentioning it. Corporations are usually taxed 2 or 3 times. And we're going to talk about mergers, share exchanges, consolidations, sales of assets, and hostile takeovers. Now, even though corporations are taxed more than once, they often get substantial tax breaks. Alright, so a corporation uses IRS Form 1120 to report earnings. Now, if the corporation makes money, it can keep them or pass them out as dividends. Now, the Internal Revenue Service does not like it if it does not get its money. So if the company keeps earnings, then it's known as the accumulated earnings tax. And usually it has to be over 2 years that the corporation kept the money without really good reason, like wanting to grow. And then it will be 15% of amounts over $250,000 that the corporation decided to keep typically. And that's known as the accumulated earnings tax, and I love to test on that. Alright, so let's talk about the taxation of a corporation. The first tax is when the corporation makes a profit. It pays taxes on those profits. And the second tax is when the corporation declares a dividend, and the shareholders have to pay tax on that same profit. Alright, so there's also the potential for state tax. And in California, we have what's known as the pleasure of doing business tax, or a tax basically for using our state's highways and emergency system. And there might also be property or sales tax on a more local basis. Now, an S corporation is a specially taxed type of corporation. And so they do get some benefits, but there's lots of requirements. They can only have one type of stocks. They can't have more than 100 shareholders. Shareholders have to be typically individuals. They can't be non-resident aliens because non-resident aliens don't have to pay tax in the U.S. Everyone has to agree to that S status as well. And they still have limited liability, so it's nice to have that limited liability and the benefit of positive taxation. Now, our S corporation is typically formed the same way. You make the election to be an S corporation later. There are time limits on when it can be done. There's a form for it, and it's passed through taxation, so it typically is cheaper than the corporate tax rate. If you give it up, you typically cannot get the S corporation status back for another 5 years, so that's something to think about. Now, nonprofit corporations are some of our corporations that make a lot of money, but they cannot give out their profit in dividends. And there's 3 main types. There's public benefit, mutual benefit, and religious benefit. And public benefit has to be for some public benefit of the public, so like the American Cancer Association. Now, mutual benefit is interesting because it can be mutual benefits of its members, so fraternity or sorority can actually count. And the religious benefit is some sort of church or Scientology that's claiming that status. Now, when a company wants to be a nonprofit, they have to determine what type they want to be. They get approval from the Attorney General, and they have to file their articles of incorporation. They file a separate application with the Internal Revenue Service for their tax exemption. They do have to have bylaws, but there's no dividends because all the profits have to be reinvested in the purpose of the nonprofit. So if it's the American Cancer Society, then they need to be reinvesting their profits in cancer research, for example. There's no stocks, there's no shareholders. The Internal Revenue Service has to agree that the nonprofit is not required to pay taxes. So there was a group of attorneys in New York that was trying to argue that they were a nonprofit, but they were in fact making a profit. The IRS didn't agree, so they didn't get to not pay taxes. And they have to file yearly paperwork to make sure that they're still a nonprofit, because this is a very special status, and so the Internal Revenue Service wants to make sure that they're still a nonprofit. All right, amending the Articles of Incorporation for most corporations is for material changes, and it's called Articles of Amendment, and you can read what these articles require on your own. Now, you typically must amend if there's any changes whatsoever to stock, and you can read some examples of those as well. Now we're on to corporate combinations. So there's different things that a corporation can do: mergers, share exchanges, consolidations, purchase of assets, stock, and hostile takeovers. And typically, board of directors and shareholders both have to agree. And if the shareholders don't agree, they might be able to have their shareholders bought back at a fair market value price. Now, typically, a merger is when Company A and B decide to form Company A. And Company A takes over all the assets, but also the liabilities. And it has a procedure. There's a letter of intent, plan of merger, articles of merger, a lot of paperwork. Now, Williams versus Stanford was a case in your book, and the minority shareholders object to the total transfer of corporate assets, and then they were able to be bought out at a fair price sometimes. So read that case a little bit more in depth. All right, share exchanges. When a buying company will buy the shares of the target shareholders can get stock in the new corporation or corporation, or just get bought out. And there's also got to be a plan of exchange. It has to be approved by directors, majority of shareholders of the target, but not the buying company. There's also consolidation, which doesn't happen too much anymore. It just doesn't make sense. A plus B equals Company C. And typically they were selling most of the assets of B and C and then buying new ones for C. So that doesn't make a lot of sense. We don't see that very often. Purchase of assets is when one company is going to purchase all or most of the assets of another. And then there has to be an agreement. There's negotiations, letter of intent, agreement. And the benefit is the buyer does not get the liabilities of the selling corporation. Now, there might have to be shareholder approval depending on the state laws, and this is typically only for the company whose assets are being sold. Purchase of stock, you take over all the rights and responsibilities of the stock. Now, hostile takeovers are interesting because it's a non-consensual taking over of one company, but going over the head of its management. You can do it through a tender offer or a proxy contest. And tender offer is when stocks are bought up on the slide up to 4.9%, because at 5%, it has to be disclosed to the Securities and Exchange Commission that those stocks are being bought up. And then still a majority of the shares has to be purchased. With a proxy contest, you're trying to get the target shareholders to vote for the aggressor's management team. And there's many different defenses to hostile takeover. Poison pill is basically giving more shares, and so making it harder to purchase the shares. Court of White Knight is when one company sells itself or merges with another company so that the aggressor doesn't take them over. Buying another company is when the target buys another company to make itself stronger, hopefully. Golden parachute is when the target company gives its management huge severance packages to make it more expensive for the aggressor to buy it. Pac-Man is when the target turns around and takes over the aggressor. And suicide pact is when one manager of the target quits, they all quit. And then finally, the crown jewels is when the target sells off its major assets that are what make it so attractive, so it's not so attractive to the aggressor. Okay, dissolution is when the corporation ends, and then liquidation is when it converts all its assets to cash. And winding up is the liquidation process, and paying the creditors, and distributing any assets to the shareholders. Now, voluntary dissolution is the board of directors and the shareholders have to approve. It might be because they're not making a profit anymore, there's a merger, there's a sale of the assets. They have to file the articles of dissolution and then go ahead and liquidate. Administrative dissolution is if you didn't pay your taxes, you didn't do your annual reports, you don't have a registered agent for service of process, then basically the government can go ahead and dissolve you. Involuntary dissolution can be done by three groups of people: the creditors, Secretary of State, or the shareholders, and the court gets involved. Now, a majority of shareholders can try to get this done because the directors are committing fraud or the corporation is going bankrupt. Creditors can ring if they're unable to get their debts paid back. They're going to have to show that the corporation owes it money and the corporation is insolvent. These are all the different reasons you read for an involuntary dissolution. And this is a case involving dissolution due to creditors. Read that on your own. Articles of dissolution. There's a lot of information that has to be in that. And liquidation, you can read that one on your own as well. Okay, so if a company is dissolving, then we have to let the creditors know. And notice has to be given to the last known addresses of the creditors, and as have to be taken out. And if somebody gets notice, they have 120 days to file a lawsuit. If they got no notice, they could potentially have 3 years to go ahead and file a lawsuit. All right. If a company is qualified in a foreign jurisdiction in another state that's not incorporated in, so basically, let's say a company incorporates in California, it's known as a domestic corporation in this state, but if it's not incorporated in Nevada, it'd be known as a foreign state, a foreign company in that state. And if it's doing business in Nevada without permission, that can be fined. It might not have the ability to use those courts, and the directors and officers might have more liability. And most corporations don't want to be considered as doing business in another state because then they might have to pay additional fees and taxes. Skipping that slide. So what constitutes transacting business in another state? Well, having a lawsuit does not. You can have a meeting there, and that doesn't constitute transacting business. You can have a bank account. You can even sell through independent contractors. What constitutes doing business is regular and continuous business of a similar nature in a foreign state, and then you might have to pay those fees and taxes. Mail order is okay. That's not considered transacting business. Owning property is okay. Isolated transactions are okay. But regular and continuous is not okay, and then they'd have to pay fees and taxes. Okay, typically a corporation is governed by the state that it's incorporated in. They might have to pay fees and taxes to a new state if they're doing business there without being incorporated there. They might have to file annual reports. They want to have good standing as a foreign corporation. If they're doing business there, then they need to pay those annual reports, pay those fees, and pay those taxes.